paragraph 78, you observed, and I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law has been contravened or is threatened with contravention." Then you at paragraph 79, you observe, "Applying the above in this matter," petition 522 that is before you now, without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration. You made a finding that the case has inherent merit. You could see it without much ado. At paragraph 93 of that ruling of 16th of October, you observed that we have no doubt in our mind, your mind was clear, my lords, that this matter raises issues of immense public interest. A matter that raises issues of immense public interest, we argue, is a matter that is infused with inherent merit. When you consider the ruling of your brother, Justice Chacha Mwita, at page 9, paragraph 3, in petition number 550, which is now before you, the judge observes, and I quote, "There is further argument that constitutional imperatives on public participation were not complied with. The petitioner has given an example of Keio South constituency to demonstrate this fact. According to the public participation results for that constituency, the total number of people who participated is given as 43. Those who are in support are given as 70. Out of 43 participants in a public participation event to remove Gachagua, out of 43, 70 approved." Well, that's the case before you. This is how we have treated His Excellency regarding Gachagua, my client. Those who did not support were 3. They also got those who did not support. Having gotten 70 out of 43, there has some residue of 3 not to support. The percentage of those who support was 162.79%. We used to distinguish law and mathematics by saying that mathematics gives us instruments of mathematical precision. I don't know what the National Assembly will do with this mathematics, but this is curious mathematics. The judge now observes, it is implausible that an attendance of 43 people would produce 70 people in support and 3 in opposition. I submit that there was no remedial measure to this blatant failure by the Senate. There was no remedial measure. This poison has worked with this dispute throughout the process up to the time we come here. I'm making out a case that this case has inherent merit by these findings. At page 11, the judge referred this matter to the Chief Justice to empanel a bench on finding that the issues raised in this petition were immense. Again, that speaks to the inherent merit. When you look at the ruling of Justice L.N. Mugambi of 11th October 2024, all the way from paragraph 38 to paragraph 42, the judge highlights the matters of grave significance that this petition raises as a precondition to referring this matter to the Chief Justice. I submit that this speaks to the inherent merit of this case. And finally, at least for my part, when you look at the order from Kerogoya in petition number E15 of 2024, which is before you, at order number 3, the judge observed that the matters raised in the petition being of great national importance and urgency. He then referred the file to the Chief Justice. And I have two observations to make here. The finding that the matter was of great national importance and urgency speaks to the inherent merit of this case. If you look at order number 5 of the order of your brother Justice Mwongo, he gave the conservatory order because of the finding in paragraph 3, in order 3. He says, in light of the nature of the matters raised as noted in order 3, a conservatory order be issued. I want to submit to the nature of those matters has never changed. For you to vacate this order, you must convince yourselves, convince us, and convince the entire Republic of Kenya that the nature of these matters has changed. The matter has remained as it was on 18th of October 2024, which was the basis for the grant of conservatory orders. I therefore submit as follows: that because this bench, Justice Mugambi, Justice Mwita, and Justice Mwongo have, in the various rulings above, already found that this matter has inherent merit, it is not open to the respondents in their application for setting aside to invite this very court to revisit that matter and reach a contrary finding in the face of the principle of res judicata that you considered and applied on 16th of this month. I also submit that because the 4 benches I have alluded to have consistently found that this court has jurisdiction, it is not open to the respondents to argue that this court has no jurisdiction and invite this court to enter a contrary view without violating the principle of res judicata that you used against the petitioners on 16th of October. I trust that my learned colleague, Mr. Macharia, has taken note of the time and therefore he is able to compress his arguments so that we pave way to the other petitioners. I urge that you grant the conservatory orders in petition number 565 of 2024 and in petition number 15 of 2024 at Kerogoya to preserve the subject matter and to give these parties a chance to ventilate themselves on the merits in the main petition. Over to Mr. Macharia.
If it pleases your ladyship and my lord, I will speak to 3 issues. The first of those issues is an issue raised most robustly by my colleague, I believe it's Dr. Yankolu, and it is the question of political question. The second issue, my lords and your ladyship, will be the question of fair hearing. And the third one will be jurisdiction in the context of Article 40. Let me begin with the last one. In response to what the petitioners will tell you this morning, you will be treated to the most astonishing claim in our 10 years of the Constitution 2010. You will be told that the National Assembly and the Senate and the Executive have a dictatorship have an autocracy on political questions, that those questions cannot be questioned by this court. That is the textbook definition of dictatorship and autocracy. The Constitution of Kenya, beginning at Article 1 and going to Article 10 and on to the end, is replete with the word accountability. Kenya is not a presidential democracy. Kenya is not a legislative democracy. Kenya is a constitutional democracy. When we gave ourselves this constitution in 2010, we introduced into it a concept known as limited government. And what that concept means is that those who are accorded powers under the constitution can only exercise those powers within the four corners of the power granted to them. That is number one. And that number two, on account of Articles 1, Article 2, and 3, all those decisions are amenable to judicial review for purposes of confirming compliance with the Constitution. My good friend, Dr. Thiankolu, and his colleagues have in their submission cited to you a case which they have extracted from the Sonko, allow me to call it that, the Sonko Supreme Court decision. They tell you that on the basis of a decision called Nixon versus the United States, you have no jurisdiction on account of the political question doctrine. But what they've done actually is that they cut out the passages and left out the decision that the court actually made. This is what you will find at paragraph 113 of the Supreme Court decision. And so far, it's the only, I think, full decision by the Supreme Court on the question of impeachments. Full decision after an impeachment. This is what they say. In that sense, and this is now a continuation from where the respondents here have cited in their submissions. In that sense, and in the exercise of these wide political powers, both the County Assembly and the Senate cannot act outside the confines of the Constitution. So that's the first point. The Senate and the National Assembly, even while acting politically, cannot act outside the confines of the Constitution and the law. That's number one. And they then say, and this is where you draw your jurisdiction from, for to do so would invariably invite the court's intervention, which is what we're asking you to do here today. They then cite the case of Nixon, which itself stated that there must be judicial review when state organs or state bodies misbehave. But this is what the court says. Courts are thus permitted to intervene where matters of constitutional violations arise. And that's not the only one, of course. We've cited before you other cases, including the Wambora decisions, where the court, both the Court of Appeal, went to great lengths to explain where you draw your jurisdiction from. So I believe the Supreme Court decision in the Sonko case should put to rest the question as to whether you have jurisdiction even on political questions. The respondents then make another submission. This is that this court lacks jurisdiction because jurisdiction to interrogate the presidency and its appointments or elections lies exclusively within the Supreme Court of Kenya. They don't say so explicitly, but they say so by way of example. And they tell you that under Article 164, I believe it is, Article 163, Sub-Article 3A, the exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the president arising under Article 140. It's important to linger on every of those words. The exclusive jurisdiction is limited to elections, number one, arising under Article 140. And there's a reason it's worded this way, and here's the reason. Now, not every election is a presidential election. Now, under the definitions set out under the Elections Act, the Elections Act is itself a statute promulgated by Parliament under the provisions of Article 82 of the Constitution of Kenya. it recognizes only 3 types of presidential elections. The first is Article 136. It is that election that leads and that has the qualifications and the mechanism for it under Article 138 that then leads to a petition in the Supreme Court of Kenya under Article 140. There is then another election under Article 139, sub-Article 1B, and you'll find this in the definitions of the Elections Act. And the third presidential election understood is Article 146, sub-Article 2B. A replacement of a deputy president under Article 149 is not an election. And I must confess that Article 149 was perhaps not worded very elegantly, because what Article 149 does is that Article 149 almost seems to have ended prematurely, because it says within 14 days after a vacancy in the office of the deputy president arises, the president shall nominate a person to fill the vacancy. So it's a nomination. The word used there first is nominate. A person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. It doesn't say anything after that. But one of the things I found when I examined another statute with similar provisions, this is Section 32D of the County Governments Act. Section 32D of the County Governments Act is actually a lot broader. It explains how that vote will be conducted, the time periods for it, the threshold for that vote. It's a lot more elaborate. But one of the things it makes clear is that the vote akin to Article 149 is an approval. It's not an election. It's an approval. And if one were to examine the Constitution further, everywhere the word election is used, and just by way of a few examples under the Constitution, Article 86, Article 87, Article 83, all of those articles, including the powers and functions of the IEBC, which my learned friend Mr. Ndegwa will be speaking to later, all of those make it clear that the election contemplated is a contested election with voters under Article 1. 14 million Kenyans. That is what the Constitution understands as an election. That then invites the jurisdiction of the Supreme Court of Kenya under Article 140. So it cannot be that the respondents get to make 2 opposing arguments. They argue that because this is their argument, this is an election, so you can only go to the Supreme Court of Kenya. But they then argue this is not an election that requires the IEBC. That's one of the things they've argued. Because an election requires the IEBC, as properly understood. So even that argument that the Supreme Court of Kenya is the only one that has the repository of jurisdiction to determine this matter does not find any basis, doesn't find any grounding in the Constitution of Kenya. You can also look at Article 106(2)(a) for what they discuss when they talk about an election. So Article 149(1) does not envisage any contest. The president nominates one name. And while I'm here, let me deal with an elephant that my learned colleagues will be throwing at you. It's actually more of a monster. In response to what we are telling you, they will tell you there's a public crisis of monumental proportions not seen since the late Daniel Arap Moi told us that he will appoint a vice president if it increases the sufurias of ugali in our houses. We'll be told this is the worst thing that has ever happened. There's a vacancy. Answer number 1. Article 148 does not 148, sorry, I believe I'm talking about the sequencing where the Speaker of the National Assembly is the third in command, so to speak, when there's a vacancy. I have been waiting for my good friend Mr. Milimo, who represents the Speaker, to shoot up to his feet and protest loudly that his client is not a vacuum. Because the Constitution says, when, I think think it is. This is Article 146, Sub-Article 2B. If the office of Deputy President is vacant, or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of the President shall be held within 60 days after the vacancy arose in the office of the President. Two things to note there. In that article, the framers of the Constitution contemplated a vacuum in both the presidency and the deputy presidency. And it is at this point where my good friend Mr. Milimo says his client Anatosha. Maybe you'll say it. I am almost certain in the event that my good friend Mr. Kamodo described here a few days ago, when he said the president might go to where people don't come back from, that we will all say we turn Atosha. He did. The record says so. Yeah, but we understood him. He was not wishing ill. So that's the first thing. The second thing, my lord, is that they contemplated we can operate for 60 days, 2 months, without either a president or a deputy president. The world will not collapse. Kenyans made adequate arrangements for the caretaker while those two are not with us. And there seems to be something magical about these 60 days that Kenyans clearly had. Because under Article 149(1), when the deputy president is impeached or there is incapacity, the president has 14 days to nominate a candidate to the National Assembly. That is number one. And because it is not obvious, or it is not a matter of course, that the National Assembly will approve that candidate, it must be contemplated that the National Assembly can refuse to vote for that candidate. So those 14 days can be repeated, which is what the Constitution says. If Parliament rejects the first candidate, the process is repeated again. And the Constitution seems to contemplate can be repeated almost indefinitely until the President comes up with a name that is acceptable. So that is number one. And there's no crisis. The world will not end as Parliament rejects those candidates. So that's number one. But the President having nominated a candidate, the National Assembly itself has then another 60 days. So we can again operate as a country for 60 days without a deputy president. And so I return to what the Supreme Court said in the Sonko case we must do, and has not been done, has not been afforded to our client, the deputy president. This is what the court says. This is the Supreme Court again at Article 114. And it's interesting because what had happened in the Sonko case, the court actually found that Sonko was not properly before it. But they then said they converted the proceedings into an advisory opinion. So they're actually giving this as a template for courts such as this honorable court to follow. Paragraph 114. To the question whether due process was followed in the removal of the appellant, the Audi Alteram Partem rule requires that those who are likely to be directly affected by the outcome of a decision should be given prior notification of the action. So they give a whole list of what must be done. Prior notification of the action proposed to be taken, of the time and place of any hearing that is to be conducted, and of the charge or case they will be called upon to meet. They must be given an opportunity to be heard. Now, it is not a matter in dispute that on the night the Senate, I and my colleagues on both sides were present in the Senate, our client was taken ill. I have subsequently read in the newspapers he had a broken heart for good reason. So he is taken ill, and the Senate then takes a vote. And this was important because the Senate had 2 days left, even in their own self-prescribed time limits. They voted, and this was not an electronic vote. They voted on acclamation to reject a motion to extend time for the Deputy President to appear
My
in
Lord,
court.
if I may, I am compelled to interrupt. My Lord, learned counsel is misleading the court. When on affidavit, it is clear that the Senate votes electronically. Senate does not vote by acclamation. I do not know what paragraph is addressing himself. Perhaps he can point the court to the paragraph he's addressing himself to on the question of acclamation. We can't just sit back and watch Mr. Macharia mislead the court.
I was personally there. Senior Counsel Mwite was there. The entire team, most of them were there. On the question of extension of time, it was by acclamation. All the ayes and all the noes, that's what it was.
And the senator was loud.
Yes. And I would ask him to please wait. He'll be a bit more bothered when I finish with my submission, so he can be bothered fully when I finish. So this is what the court says. They must be given an opportunity to be heard, to call witnesses, to be represented by counsel, to be availed adequate time and facilities to prepare, and if the accusations are proved, to be given the reasons. This is important. The Supreme Court says you must be given reasons for your decision. There are no reasons. They voted on grounds submitted to them by the National Assembly. They did not give reasons for that decision. Of course, beyond there, they are also entitled to challenge the decision. Again, you've been told these decisions are not challengeable. The Supreme Court says the accused must have a right to challenge the decision, if against them, before a higher court or tribunal. At paragraph 115, Article 47 of the Constitution enshrines the right of every person to fair administrative action. The manner of actualization of those rights have been enacted in the Fair Administrative Actions Act. Now, when this Honorable Court retires to do its ruling, I would invite you, with tremendous respect, to pay attention to sections 4 and 5 of the Fair Administrative Action Act. They're important in more regards than one. Senior Counsel Paul Mwite has alluded to the question of public participation, and so will some of my colleagues who will come after me. When the National Assembly conducted what it called public participation, it did not avail to the public the response by the Deputy President. What they did is prepare a charge sheet, a copy of which you will find as Annexure 8 of our affidavit in support of the petition, which for ease of reference is at page 498. That charge sheet asks 3 questions. It first sets out the 10 grounds that the motion promoter had set out, and then asks people, do you agree that the Deputy President should be impeached on these grounds? Do you not agree? And then there was a third one, other. That was it. They were not told what his response was, nor was he given an opportunity prior to this process. Because the only way, and you'll find that this is one of the things the Supreme Court says under the Article 47 in Fair Administrative Action Act, the participants in this public participation must know both sides of the story to make an informed decision as the people who voted in this manner. The court then goes on at paragraph 116. In the process of removal of a county governor, and for this case, the Deputy President, the right to fair administrative action under Article 47 and the right to fair hearing under Article 50 of the Constitution all accrue, and I'm paraphrasing here, to the Deputy President before a decision to remove him or her from office is reached. An unfair removal is one which goes against the principles of natural justice, just like I've demonstrated, which implies that no adequate notice was given, that there was bias, and where the hearing was not fair. In our amended petition, which you will see in the fullness of time, we have given particulars of how each and every of these issues was violated. The Senate and the National Assembly, first and foremost, constricted the time allowed by the Constitution for themselves. They cut their own time short. And so no one had sufficient time to do anything. We have said they introduced new evidence as the trial was going. There was panel beating as the matter was going on. And as I've said, there was a lack of fair hearing. Though, this is Supreme Court, though a political process, impeachment is sanctioned by the Constitution and the law and is not a platform to settle political scores. This speaks to what Senior Counsel Paul Muite said a few minutes ago. It's not an issue of ticking boxes, going into a room and saying 300 of us have said you're a bad man, you must go. You're a bad woman, you must go. You must comply with each and every of the provisions of the Constitution. Bearing in mind that the removal architecture in the Constitution, the law, and the standing orders are designed to achieve accountability, political governance, and personal responsibility, and are not aimed necessarily to find criminal responsibility. On the question of natural justice, this is what, this was a decision by, I believe, your brother, Justice Odunga. It's in our list. This is miscellaneous civil application number 266 of 2017. He cites at paragraph 69 a case, I believe, from Uganda. It is a cardinal rule of natural justice that no one should be condemned unheard. Natural justice is not a creature of humankind. They are asking you to take away a creature, and let me read to you what it says. It was ordained by the divine hand of the Lord God. What God has given us, do not allow these respondents to take away from the Deputy President. And that any law that contravenes or offends against any of the rules of natural justice is null and void and of no effect. The rule, as captured in the Latin phrase audi alteram partem, literally translates into hear the parties in turn, and has been appropriately paraphrased as do not condemn anyone unheard. That is what the Senate did to the Deputy President. You cannot allow their resolution to stand. There is a decision, I will not read this for you, but this is a decision of the High Court, a 3-judge bench, Republic versus National Land Commission. I believe this is miscellaneous application number 266 of 2017. At paragraph 109, the decision of the Supreme Court of Kenya in Speaker of the National Assembly versus Attorney General and 3 others, where the court again restated, the Supreme Court, your jurisdiction in these circumstances. And then to the Senate proceedings I've just read out for you. In the Wambora, in the Martin Wambora case, this is what, this is the case, this is, it's cited in the Mike Sonko case versus clerk of the Nairobi County Assembly. At paragraph 226, I believe this is the High Court decision, this is what the court said about what my good friend Professor Ojenda was getting a bit hot under the collar over. Although it does not fall within our remit to direct the legislature on how to perform its functions, we are of the considered view that impeachment of a governor is a serious undertaking, just like a deputy president, as the end result can lead to the removal of a popularly elected governor. The deputy president before you and the president who ran for election in 2022 were elected by a vote of slightly over 7 million people in this country, out of 14 million people who participated. It's a very serious matter. For this reason, we recommend that it will be desirable that future impeachments proceed through the committee route as opposed to the plenary. This is what the court is saying. We say so because when the special committee is appointed, it has 10 days to deliberate on the matter, thus giving ample opportunity to the parties to adequately prepare their cases. The Senate chose not to avail itself of this constitutional mechanism. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary. The trial of the deputy president was held entirely in plenary. And a lot of things, when you look at the Hansard, for example, there was a lot of issues raised about a will, about a succession matter that has nothing to do with the Constitution of Kenya. When you look at the Hansard, a lot of things that had nothing to do with this constitution. And here's the problem. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary, which can be perceived to be a mob lynching process, which is exactly what happened. That is our submission before you. It is what my late member of parliament from Kangema, the late John Joseph Kamotho, used to call kura ya makelele. Now, under the grounds for granting a conservatory order, one of the issues the court is called to look into is the question of whether the orders or whether the hearing will be rendered academic or nugatory. Now, at paragraph 20 of our supplementary submissions, which are dated 28th of October, 2024, we have cited before you a case by the Court of Appeal, Attorney General versus Matindi, and 55 others, where the court explains the following. A successful appeal is not reduced to a mere Pyrrhic victory or paper judgment. Whether or not a matter will be rendered nugatory is determined on a case-by-case basis, depending on the peculiar circumstances of the case. But ordinarily, the court will grant relief if what is apprehended cannot be undone once it happens, or cannot be undone without undue hardship or expense, or cannot be adequately compensated by an award of damages. The court takes into account the respective hardship that grant or refusal of relief is likely to wrought on the parties. I want you to take my colleagues' submissions where they say you cannot undo. Once a new candidate for deputy president is nominated and sworn in, they say the court has no jurisdiction to undo that appointment. This is what they're telling you. You cannot undo a deputy presidential nominee who has been sworn in and has taken office. This is what they're telling you. At any length, they tell you, this is a political question, don't even look at it. That's why they began. Don't even look at this. The president knew what he was doing, take him at his word and at his actions. So that's one side of the balance of the scale. On the other, you have a sitting deputy president who is before a court of law as he ought to be. If, in the unlikely event, his petition were to fail, all he does is go back home and we swear in the new one once the petition is dismissed. But conversely, if you swear in a new deputy president, you kick in motion a whole series of events, including a president, a deputy president, who is now exercising constitutional mandate, who is chairing cabinet committees, that may ultimately be found to have acted outside the Constitution of Kenya. The balance lies in granting conservatory orders so that we can do this in a civil manner. What former Supreme Court Judge of the Supreme Court of Kenya, Justice Ojwang, used to call a pacific resolution of the dispute. As I said, the Constitution has given ample time for all of us to interrogate these questions. 60 days is the magic figure the Constitution gave us. Let's not be in a rush to undo the timelines given to us by the Constitution. And finally, the decision of, I believe, Gachagua Munya, the question of the public funds that are expended, swearing in a new deputy president, getting him a whole fleet of cars and workers, and the trappings of power, and as is the custom, perhaps even doing the road to his village home, all these sort of things. So let's hold our hands until we can determine whether the process that led us to this day was done constitutionally. That is the Peter Gachagua Munya decision. My lords and your ladyship, the decision you make in this matter will echo in eternity. It will be a turning point as to whether we continue being a constitutional democracy or a dictatorship and an autocracy. I beseech you, do not let us go down the path of autocracy and dictatorship. Thank you for the privilege of your attention and your time. Unless you have any questions for me, I'll hand over to one of my colleagues. Thank you.
Thank you.
My Lord, my name is My Lord, my name is Kibe Mungai. The team leader is Paul Muite, Senior Counsel, assigned this application, the one from Kerogoya, to me, Professor Ogada, and Mr. Ndegwa Jiro. as I had already indicated to the court, and with the benefit of the submissions from my learned colleagues, we shall try to do our business within an hour. So I'll start first, followed by Mr. Ogada, and then Mr. Mbegwa, for purposes of presenting that application. My Lord, let me start by thanking the court for the decisions that it rendered on last Friday on the questions of directions that it gave for the hearing of the petitions that are before the court. My Lord, I confirm that the process of amending the various petitions is ongoing and will be filed in accordance with the timelines fixed by the court. My Lord, going by the timelines that you gave, it is also my pleasure and appreciation, and that is in ensuring with the compliance with the Mutunga rules, that it is possible for your lordships to ensure that in the same way that the month of October we dealt with the political aspects, with the political phases of impeachment, that it is now possible, courtesy of your directions, to ensure that we can be able to have a judgment on merits for purposes of the various petitions that are before you. That would be an absolutely important issue for this court to remember, because it is being made as if it will not giving due process and ensuring substantive hearing of this matter, that we shall be here until forever. My Lord, all these businesses can actually be concluded within the month of November. That being the case, my Lord, by way of introduction, let me say two things in my own words as counsel representing, I believe, the 4th to 8th petitioners who filed the application that is before the court.
The date of your application?
Yes, my Lord, that is exactly the issue. 18th, my Lord. The application was filed on the 18th of October.
Yes. If we put it there. Okay.
My Lord, 18th, it is supported by an affidavit sworn by Honorable David Munyi Mabenge on the same date. My Lord, for purposes of the documents, let me start there. We have filed submissions. The submissions were filed yesterday. There is a supplementary we filed today, and we have filed various responses to the affidavits to set aside that my learned colleague, Mr. Ogada, will be referring to them. My Lord, that being the case, I wanted to say that by way of an introduction, there are two broad issues that I can be able to say. My Lord, thank you. Yes. My Lord, the first issue is that the petitioners moved the court applicants moved the court in Kerugoya in view of the fact that under Article 3.2 of the Constitutions, every citizen of Kenya has an obligation to defend and protect the constitutions of Kenya. That's a broad mandate. And of course, further to the other mandate, that under the Bill of Rights, from Articles 19 to 23, where the Bill of Rights is being violated, they are permitted to come to this honorable court to seek for the appropriate reliefs. And therefore, that is the basis upon which they came and have moved this honorable court. My Lord, the second broad issue that I wish to cover at this particular stage is to point out that what is basically the big thing about the matters that are before you. My Lord, the big issue for purposes of the matters that are before you is that these impeachment proceedings, after you hear us, two possible scenarios are clear. Number one, the Deputy President, who has already argued his application, as his advocates has pointed out, is an elected Deputy President, an election that was conducted on the 9th of August, 2022. My Lord, on account of the vote of impeachment passed by the Senate on the 17th of August, 2024, if the process concludes in accordance to the manner in which it has so far been implemented under Article 149(1) of the Constitution, it would result into Kenya having an appointed president 2 years after one who is elected was put into office. My Lord, that's a big thing, whichever way you look at it, for the simple reason that one of the important devices of the 2010 Constitution was to ensure that the holders of the offices of President and Deputy President have the direct mandate of the people. So, in a matter where that important issue of our constitutions could change, it is our submissions that every absolute care must be taken to ensure that the process and the law leading to this very critical political and legal transformation on our constitution has been addressed. How would this be addressed? My Lord, we shall be arguing together with my learned colleagues that the only way in which this can be done is through the hearing on merits of the petition that are before this court. My Lord, having given those introductory remarks, let me come to the application of the 18th of that day, and by highlighting the issue that we both clearly knows. My Lord, impeachment, and many cases, I will not go through them. The many cases that have been cited of impeachment shows that impeachment in Kenya has 4 processes. One, where allegations are made, that is purely political. Muduse went around, collected his evidence, presented. There was a motion, I believe, dated 29th of September, asking Parliament to have this 26th. I'm told 26th of September. That's the stage 1 of the political process. Stage 2 of the political process is the stage where the National Assembly approves by a vote of 2/3 of all the members to allow to reject the impeachment motion. My Lord, that was done. There are various issues that have been raised in the majority of the petitions that will be argued in the fullness of time that shows the significant problems when this matter was at the parliamentary level. Topmost of them being the impartiality of the Speaker and the Deputy, together with the manner in which public participation was handled. Stage 3, my lords, is the stage of the Senate. The law clearly talks about what the Senate should do, how the voting should be done, and again, there is evidence. My learned colleague, Mr. Ongoya, and Honorable Muite, they pointed out at the significant problems that we had there. I am most interested, my Lord, in the 4th phase. The 4th phase of impeachment, as it has now been established in our jurisprudence, is where these courts seeks to establish whether there was compliance with substantive law and procedural law by the political organs upon which the mandate of impeachment has been entrusted upon by the Constitution, other laws, and the respective standing orders. Again, my lords, that phase that where the court is supposed to deal with this issue, it is our submissions that this is the stage that this honorable court must ensure, because it is the court that all aspects and proceedings are dealt with in a manner that we all had, and I'm happy for the time that the court has agreed to allocate us, so that the court with sober minds can be able to decide, have the laws of our countries been upheld or not. My Lord, there are clear guidelines that have been set out by our constitutions for purposes of doing that. And my Lord, because we are here because of an application for conservatory orders, under Article 159 of the Constitutions, this court has an express duty that in exercising the delegated judicial power of the people of Kenya, it is required, the certain guidelines have been given by the Constitution under Article 159, that is besides other provisions of the Constitutions. And one of the most important one is that that the court will do substantive justice. Substantive justice is an important issue, and it has specific meaning through the very many decisions that have been rendered over time by the courts of this country. And the clear meaning in plain English, because it is important we understood in plain English. In plain English, it means a very simple things. That, for example, my lords, if we have a case of a goat, Mr. X and Mr. Y have a case of a goat, this goat should remain alive and should so that at the end of the decision, the court can decide whether it belongs to Mr. X or Mr. Y. That is the very simple meaning of substantive justice. So that, my Lord, substantive justice, therefore, conservatory orders, is a mechanism that our laws preserves the goat. Our laws preserves the subject matter of the case. The subject matter of the case, my Lord, is the questions of vacancy in the office of the president. Going by the Senate, the deputy president was impeached. On account of the orders that have been given, that office is yet to be filled. So that, my Lord, the question, therefore, is easy to define and can be defined this way. That, as we wait for the hearing and determinations of this case, it cannot be settled at the interim level that the Honorable Kindiki will now be the Deputy President of Kenya, so that as we argue the petitions, there is already the impeachment process has been concluded to the disadvantage of the other people, of the other person who is seeking the same office. So that, my Lord, is a simple issue that is very easy to define. So that, my Lord, we shall be arguing that when we come to that particular issue, why on earth, because you have before you, because if a conservatory order is the legal mechanism, the legal device that is established by the constitutions to preserve the substratum of the matter and for this court to do substantive justice, how on earth does the respondents expect that substantive justice will be possible if the trophy that is being tussled over, that is being contested over, is handed over to them? My Lord, all systems of justice would be offended to be told that it is possible at halftime for one team to be declared to be the winner before the matches is concluded. Why can't we wait for all these issues to be concluded? It is a simple meaning of what substantive justice is all about, and the courts, the duties of the court to ensure that the ring is held even for all the parties, so that we do not argue over an academic matter, which would be the worst issues that can happen. My Lord, there is the case of the Gatirao Peter Munya. I'm coming to the applications for conservatory order. The principles are very clear. I just need to go on them as quickly as I'm able to. Under Gatirao Munya and other decisions, we have a big authorities, many authorities. The issues were set out very, very clearly. And there are three tests. The first test is on the prima facie case. My Lord, my learned colleagues have set out the various many legal issues that are there. That from the standpoint of the applications that we are arguing before you, there are 5 issues for purposes of the prima facie case to comply with the Gatirao Munya case. The first one, my Lord, is public participation. I don't need to go into that. It's a substantive issue in the majority of that issue. My Lord, the second issue is what we call the legality of the standing orders of the Senate. My Lord, in the petition filed in Kerugoya as 015, the petitioners, amongst other things, are saying that although the Constitution provided for clear timelines on how, for example, the business is going to be conducted, and specifically said that this investigative committee is the only committee that can be able to discharge that constitutional function, the Senate established standing orders under which the plenary of the Senate can also resolve that issue. The Constitution of Kenya does not provide for a mechanism on how the Senate can discharge that function. But it is very clear on how that investigating committee is supposed to conduct its business and how the right to hearing is to be given after a finding has been made that there is a case worth responding to. My Lord, I submit that's a big issue on the standing orders that were used to pass the vote of impeachment. The second issue that has been sought in that case is the issue of interpretation and application of those laws on impeachment, 44, all those laws, 48, 144, 144, 149, all those have been raised. My Lord, as you clearly knows, this is a first impeachment for purposes of those laws. And therefore, if a question of interpretation has been raised specifically before you, it underscores the necessity to ensure that on merits, this court actually determines and interprets the law, so that the next time we have probably to do it against the president or against Kindiki, if he gets there, the law would be clear and we shall not be going through all these things. So a serious issue has been raised by that petition. The other serious issues that have been raised is, of course, the fairness of the Senate proceedings. I will not go into that because already the lawyers for the deputy presidents have raised that issue. And the fifth important issue is the issues of nominations of the Honorable Kindiki. There are issues of the nominations. My learned colleagues will say more about that. But as we wait for their turn to come, the only two issues that I need to say at this early stage is to point out the fact that under the constitutions, I believe Article 137 of the constitutions, any person occupying the office of the deputy president or the office of the president must be qualified in accordance with the constitutions of Kenya. Under the impeachment articles of the constitutions, these issues of the constitutions on the qualifications are not set out. So that because they are not set out, it is an assumption that when reading the Constitution holistically, this court will go to those other specific provisions of the Constitutions where the issues of qualifications are set out. My Lords, those issues of qualifications are many. One, and the body under the Constitution, my learned colleague Mr. Ndego will say more about it, is that the IEBC confirms whether any person has those qualifications or not. I don't think that is a contested issue. I believe it is also not a contested issue that at the time that the President of Kenya appears to have received some letter from IEBC confirming that the Honorable Kindiki is duly qualified to hold the positions of Deputy President, courtesy of Article 149 of the Constitutions, we did not have IEBC. Of course, various arguments can be taken by the parties that are before you. Those arguments cannot be concluded. Those arguments can only be arguments to justify whether or not the conservative orders will remain in place or not. But they'll have to be settled when the petition has been heard. The second important issue on the aspect of the nomination of Kindiki that I need to point out is this, that even assuming the president did the right thing and everything else that he was doing, this court should be concerned by the fact that whilst the case was still going on before the Senate, the National Assembly scheduled a meeting by the National Assembly, which under Article 149 has 60 days, a meeting to occur the following day, within about 7 hours after the vote of the Senate. Why should this concern the court? It should concern the court for the simple reason that under Articles 10 and 118 of the Constitutions, Parliament cannot pass a law or make important decision like approval of the Honorable Kindiki without engaging in public participation. The cases are so many for me to cite them. The jurisprudence is so clear for it to be disputed. So that, my lord, the argument that we shall be putting on the issue of the nominations, on the face of it, unless this honorable court is able to say that at this stage, that public participation does not apply to the nomination and approval by Parliament, then, my lord, it is clear that this is the kind of case in which you are duty-bound to confirm the conservatory orders until this petition is heard and determined. Because the precondition would have to say, we have excluded this process from public participation. You would have to resolve the main issue, one of the main issues, at this stage before the petition has been heard. That would obviously be irregular. Now, none of us expect it to happen. I still wonder how the respondents would expect for them to get such kind of an order. I go to the second test, and this is the test of whether those orders will be rendered negatory. My lords, again, I will not use the word no-brainer, but my lord, this is not a difficult argument to be able to resolve, and I believe I had a little bit say something about it. But my lord, the whole argument would be this, that if the whole argument, and that has been our case since we first came here last Tuesday, that we cannot, my lord, be able to have a situation in which the petitioners are saying the constitutions of Kenya has been systematically violated, and that all these obsessions with the application to set aside the conservatory orders that are in place are meant to complete the violations of the constitutions. My lord, under the constitutions, your first duty is to defend the constitution. That duty is particularly greater for the simple reason, is it called Meduse? The MP, Metuse, that one. When the mover of the motion had that duty under the constitutions, President of Kenya had that duty when conducting, making appointment under 149. National Assembly had that duty, and the Senate. But my lord, you are saying in those 5 instances, the constitution has been violated. And because, my lord, the constitution has been violated by individual state officers who are under a duty to uphold the constitution, then the duty of this court to ensure that we do not turn this constitution into a mere platitudes, into a hollow documents, a false prospectus, is all the more greater. And it is for those reasons, my lord, that I would be saying that everything would become negatory when they can be able to say mission accomplished. They can go one day after the ruling. They can go to Uhuru Park or whichever other place for them to say we are swearing Kindiki. That would be a mockery of justice. But there is a greater mockery of justice that I would want to point out. Because this thing, and to break it down for the people, every order in the normal litigations we do with every day, and you say somebody's rights are going to be violated. If somebody is saying I should not be hanged, I was not convicted properly by the High Court, if, my lord, that person is hanged before he has been heard by the Court of Appeal, clearly it would mean that the process of justice had not been completed, yet we have hanged the guy. My lord, in America, they keep on hanging people. Many of them terrible criminals, mass killers. But my Lord, you will observe that at the time when we see these televised killings in America, it is always after they have exhausted judicial process, so that they are sure that process that are irreversible take place after every legal benefit and protection has been accorded. One of those that is important, my Lord, is captured under Article 27 of the Constitutions, the right to protection of law. So that the issue, as long as I'm in court, the matter is not yet over. It might well be possible that we might lose this application, the interim application that is before the court. But we might also win it, and we are likely to win it. So that because, my Lord, of that issue, that a person may actually succeed at the other stage is the reason why you prevent taking irreversible decisions. And my Lord, what is the scenario that we are talking here? My Lord, with the scenario here we are talking about here is simple. Immediately after assuming the orders were lifted, that's the scenario I want to describe. What is it that is going to happen? My Lord, we would have a scenario where the Chief Justice, whilst these proceedings are pending before the court, would have to preside over the swearing in of Honorable Kindiki.
My Lord, is it in order for my learned friend to keep speculating about the swearing in of Professor Kindiki?
The issue of swearing in
and
is
also, and he's referred to it 3 times now. This is the 4th time.
My Lord, I believe that's the law. They have been saying they want to.
And my Lord, whereas you are
then.
I was to ask my Lord, what is the dispute before you? Is it the impeachment and whether it was lawful, or is it the nomination of the second interested party? Because
first of all, it's both, and I would want some protection for me to conclude so that we are all fair. They will have their time to respond, and I will not interfere with it. My Lord, so that the important scenario that we must seek to avoid is a situation, and this is matter, it is also a matter both of the Constitution and statute law. My Lord, the issue is that if we get ourselves into a situation in which the Honorable, the Chief Justice, might have to preside over the swearing in of Honorable Kindiki while this petition is pending, my Lord, that, to borrow the words of Honorable, my friend Muigai, Senior Counsel, would be the greatest absurdity that we can encounter. Why is it an absurdity? It's an absurdity, my Lord, for the simple reason that one of the authorities that we have cited is the Assumption of Office Act, where, because of the experiences that this republic went through in the years 2007, 2008, specific laws had to be made to ensure that not only will this event be a public event. That's number one. But the more important issue from the standpoint of law is this, that before we get there, all legal disputes, contestations over the right to occupy that office would have been resolved. And my Lord, that is the reason precisely why they say, after the Supreme Court has confirmed the validity of those 2 positions, then you do the swearing. My Lord, it would amount to taking us back if that aspect, that rule of civilizations, were to be taken away on account of the setting aside of the conservatory orders that were issued, and for very good reasons, by your brother judges. I don't know whether there was a sister, by your brother judges. So that, my Lord, the issue, as far as we are concerned, that is an absolutely important issue. We go to the next important issue, public interest. My Lord, public interest has been defined in very many cases that are before you. And my Lord, these public interest issues are just supposed to ensure that in administering justice, the court will do the right thing because we actually have a transformative, one of the best constitutions in the world, for the simple reason that we wanted to be a good example across the world as a leading constitutional democracy. And as a leading constitutional democracy, the issues of public interest is placed at the heart of our constitutional order. I go, my lord, to the definition. This is the only long passage that I will be reading. And this is, I gave the supplementary authorities earlier. This is in the famous case of Murungaro, Christopher Daradhi Murugaro versus Kenya Anti-Corruption. This I'm citing the passage appearing at page 7 to 8. My learned senior, Gedhu Muigai, will be familiar with this decision. My lord, from the last paragraph, what did the Court of Appeal say on public interest? I read, it said as follows. Lastly, before we leave the matter, Professor Muigai told us that their strongest point on the motion before us is the public interest. We understood him to be saying that the Kenyan public is very impatient with the fact that cases involving corruption or economic crimes hardly go on in the courts because of applications like the one we are dealing with. Our short answer to Professor Muigai is this. We recognize and are all aware of the fact that the public has a legitimate interest in seeing that a crime of whatever nature is detected, prosecuted, and adequately punished. But in our view, the Constitution of the Republic is a reflection of the supreme public interest, and its provision must be upheld by the courts, sometimes even to the annoyance of the public. The only institution charged with the duty to interpret the Constitution of the Republic and to enforce those provisions is the High Court, and where it is permissible, with an appeal to the Court of Appeal. We have said before and we repeat it. The Kenyan nation has chosen the path of democracy. Our constitution itself talks of what is justifiable in a democratic society. Democracy is often an inefficient and at times a messy system. A dictatorship, on the other hand, might be quite efficient and less messy. In a dictatorship, we could simply round up all those persons we suspect to be involved in corruptions and economic crimes and simply lock them up without much ado. That is not the path Kenya has taken. It has opted for the rule of law, and the rule of law implies due process. The courts must stick to that path, even if the public may, in any particular case, want a contrary thing, and even if those who are mighty and powerful might ignore the court's decisions. Occasionally, those who have been mighty and powerful are the ones who have run to seek the protections of the courts when the circumstances have changed. The courts must continue to give justice to all and sundry, irrespective of their status or former status. What orders should we make in the motion before us? So then, my lord, I make 3 points with regard to what is public interest as understood by the Court of Appeal. Number 1 is that public interest means enforcement of the constitutions of Kenya. Secondly, my lord, to make the point from what we have cited, that the first duty of ensuring that you both protect the Constitution of Kenya and you protect public interest is vested in the High Court. Every other court above the High Court, the Court of Appeal, the Supreme Court, they can only do that on the basis that they are sitting in an appeal on a decision already made by the High Court. So that, my lord, it will be the submission that this reinforces the huge burden that this court must undertake. And my lord, the final issue that was being understood here is to say a constitutional democracy would not mean anything unless due process is upheld. And due process is the first duty of the High Court to ensure that in whatever dispute that is before the court, before it is decided, the court has confirmed due process has been observed, and as a constitutional democracy, that is a standard, because they try to compare ourselves with a dictatorship, that as a constitutional democracy, we can live with the decision. As my learned colleague, Mr. Ngoya, was saying, we cannot possibly live with a decision in which we would be seeing the Chief Justice, where, if that were to be the case, you would be seeing the Chief Justice swearing Honorable Kindiki while we are arguing this matter before the court. So that the rules are clear, the rules do not require much elaboration on what they mean. And since that criterion of public interest has been made by the Supreme Court itself, my Lord, I urge you to uphold it in the manner that will best ensure that the constitutions of Kenya and its dignity have been upheld. My Lord, there is the question, so that I believe that we are very clear on public interest, except to emphasize that for the specifics of this case, what does the call of public interest require this court to do? It's a simple call, 5 quick things. Number 1, to confirm that the law on impeachment has been properly interpreted and applied. That's the first issue. To confirm that the laws on impeachment has been properly interpreted and applied. Number 2 is to achieve substantive justice for the parties, so that when a judgment will be issued by this court, at least everybody can win something, that nobody goes home with a whole of victory. That is the whole idea of substantive justice. The third issue is to determine that the issues of the violations of the constitutions is done while the matter is still alive before the court. My Lord, very serious issues on Articles 27, 38, and 50 of the constitutions have been raised. They are all under the Bill of Rights. We urge that while public interest needs to be upheld by ensuring that when this court pronounces itself in a judgment, those issues would not have been turned into academic. Number 4, my Lord, is to ensure that the integrity of the presidential or political succession that is written in express law under our constitution is not rendered ridiculous or ineffective. And in those, I point out what we had said earlier. The desire of the makers of the Constitution was any person who will hold the office of Deputy President and therefore can potentially become President without an election ought himself to be an elected official. So that it's a big thing if this office, and without good reason, except political malice, is held by an appointed person. It is in public interest that an elected deputy president, except for the clearest of evidence, except for the greatest of sins that are clear to all men of justice, is not removed from office. My Lord, the 5th issue is to do this, that this court protects the constitutions. I've already talked something about it, so I don't have to go much into it. My Lord, there are only 2 decisions before I sit down that I would like to point myself to. There is the issues of Githunguri versus Attorney General. It is one of the cases that are before you. The facts in Githunguri are notorious, and they are also notorious for the simple reason that that decision, those old advocates who are there, Kina Paul Muite and Dr. Gibson Kamau Kuria, tells us that it was largely, though it was a 3-judge bench, it was written in the style of Chief Justice Madan. My Lord, that issue said something that is important to me, the younger advocates in Kenya. And what it said is this: it emphasized the question of justice. And it emphasized the question of justice is the simplest meaning in plain English. You need to ensure everybody has a fair and square deal. This is to say that at the end of the day, everybody will leave the court and says, probably my advocate was not as good as I thought, but the judge did their best. But at the end of the day, let it be very clear that the court did everything that is possible to ensure that justice in its substantive form is achieved. This decision was rendered in 1984, long before the article on 159 was written, and that is why it is celebrated. And my Lord, it is also celebrated, and I am mentioning here for that reason. Whenever honorable men, candidates before the Judicial Service Commissions are called upon to name whose jurisprudence has affected them. It is Justice Madan that is mentioned very many times. I will strive to be like Justice Madan. And my Lord, it is for good reason. All of us celebrate Justice Madan because he strived to do justice. But my Lord, in the same case, the older lawyers also told us about Alan Hancock's, about Dugdale, and even about Chunga. They tell us all these stories. But my Lord, in those interviews, I do not hear anybody saying I want to be like Alan Hancock's. So that, my Lord, I cite Madan in order to support the proposition that Judge Madan would never remove the conservatory orders that are before you, under the principles of doing justice and offering everybody a fair and square deal. The last case that I would want to cite, before I hand over to my learned colleagues, Professor Ogada, has he gone? Oh, I thought whether he has disappeared. My Lord, before I hand over to my learned colleague, is to point out to one little issue.
The petitioners, you have exhausted 2.5 hours. Budget how you are going to...
Yes, sir. Yes, my Lord, we are budgeting.
With the remaining,
yes,
no more than 30 minutes.
Yes,
anybody
my Lord,
who wants
understanding.
Submit on your side.
Yes, yes.
We'll
try to do our best.
Have no more than 30 minutes.
Thank you. We'll do our best. My Lord, for purposes of this case, this is the only thing I'm citing before I go. This decision, like you've had very many other decisions on constituent power and everything, this will be an international decision. It's a decision that will be read by universities across the country. And therefore, the least that I can do is to confirm that the lawyers for the petition are still familiarize themselves, as Macharia tried to do, with what other courts internationally have said. There is just like a small issue that I want to address myself to. My Lord, in 1928, in the case of Olmsted versus United States, one of the most celebrated justices of the U.S. Supreme Court, Justice Brandeis, says as follows. This is important. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. End of quote. I quote the words of Justice Brandeis in order to make the point that in the matters, the proceedings before this court, we have been treated to a scenario under which an impeachment process that, if you read the constitutions clearly, is a process that ought to be a legislative one, a process conducted by the legislative organs of the Kenyan state, has been converted into an all organs of government project. With the result, my Lord, that if the petitioners turns out to be right, you would then find ourselves in a situation whereby, like in BBI, this process of impeachment of the deputy president may end up being indicted as being a process that ended up being a government project, contrary to what was clearly spelled out by our laws. And my Lord, if it turns out that all laws were broken, and virtually out of the constitutions, I was counting them yesterday, it looks that 30 provisions of our constitutions have been seriously violated in the manner that this process has been undertaken. Then we have a situations that Justice Brandeis had in mind when he talked about the government, which should be the lead in upholding the law, ends up being the principal breaker of the law, the principal violator of the constitutions. It is within your hands, your lordships and your lordships, to ensure that does not become our scenario. My Lord, Macharia, my colleague, emphasized something, but I want to finish by adding something. My Lord, in June 1982, when Kenya was legislated, into saying that Kenya is a single-party state and KANU is the only legitimate organ. This was through a long process. Honorable Orengo, Honorable Muite, Gibson Kamau Kuria have told me the intricacies of the day, what actually happened. My Lord, the month of October 2024, we have experienced events that the senior citizens of Kenya likened to the events of June 1982, when everything in Kenya suddenly changed. Kenya ended up to being it was a restricted democracy, but all the guardrails were removed after June 1982. Your Lordships, I urge you that if these petitions, if these proceedings end up in a manner that does not uphold our constitutions, then this constitution may face the same plight that the former constitution faced after the events of June 1982. We must hold and ensure the events of October 2024 remains regrettable and an aberration on Kenya's constitutional order, not the norm. My Lord, I am thankful for the time. My learned colleague, Mr. Ogada.
Thank you. How many people are yet to speak?
For these applications, there are two. I was with Mr. Ogada and Mr. Ndegwa. They have heard you when you talked about 30 minutes. They will try to divide the time amongst themselves.
My Lord, I'm also...
That contrary to the submissions made by my learned friends, Articles 47 read together with Articles 50 and Article 25(1)(c on the right to a fair hearing were complied with. And I will show, my Lord, that as of the time that notice was received in Senate by the Speaker on the 9th of October 2024, notices were issued to the petitioner to file all the documents as prescribed and to defend himself to every question that was raised in the National Assembly, which, my Lord, you recall, had voted by 282 members to impeach the Deputy President. The right of fair trial, fair administrative action under Article 47 and the right to a fair hearing were therefore preserved. And I will just demonstrate as I move on to show that once the 16th and the 17th were gazetted as the dates when the Deputy President would be heard, and that would be the Wednesday and Thursday of October 2024, the motion, the 7-day period when motions and pleadings were exchanged then commenced. And all parties were aware that the Senate investigations would take 2 days. Your Ladyship and my lords, parties were then invited to respond to every allegation. This was a two-tier trial, my lords. The National Assembly, sitting as the initial chamber that received the impeachment motion, voting in the affirmative for the impeachment motion, no-brainer. The Senate, as a trial chamber, my lord, Articles 94 and 95, donating powers to Senate and to the National Assembly respectively. The Senate then proceeded to afford an opportunity. And I want to just demonstrate, my lord, that Article 1(2) of the Constitution designates Senate as the National Assembly as speaking for the people under Article 1. Because the people may either access their powers directly or through their elected representatives. So my lord must read the Constitution in the sense that the Constitution then, speaking through the people, Senate was the trial chamber that undertook the trial as by the Constitution contemplated. My lord, what happened on the 16th was the commencement of the trial. And it's important to respond to this factual question, that the petitioner participated in the entire trial. Only the petitioner, my lords, had the opportunity to cross-examine all the witnesses presented by the National Assembly that presented this case before the Senate. Senate sitting as a trial chamber as a whole, and therefore as a quasi-judicial body, each senator considering the allegations and bundles served to every senator prior to the trial. My lords, it was on the 17th, and this is an important distinction. At 2:30 p.m. after Senate had adjourned at 1:15 p.m., that Senior Counsel Paul Mwite presented to Senate an adjournment on the basis that he could not trace the petition of the Deputy President at the time. He informed the Senate that he had learned of his client's illness but did not reach him. He then sought an adjournment to 5 p.m. He had 2.5 hours to trace his client. My lords, there's a curious point here, and this is important, my lords. The provisions of Article 145, 5 and 6, and I want to refer to those articles, provide, my lord, that at an impeachment hearing before Senate, a party may be represented. 145.5, the President or Deputy President shall have the right to appear and be represented before the special committee during investigations. This article was wholly satisfied because the Deputy President was present throughout the trial. My lord, then Article 145, 6, A and B then step in. If the claims have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. My lord, Senate accorded the Deputy President an opportunity to be heard. How was that accorded, my lords? That was accorded, my lord, first to be heard through the pleadings filed in Senate. That is one. But number two, my lord, he was present during the entire presentation of the case by the National Assembly. But third, my lord, he was given and afforded an adjournment at 2:30, from 1 p.m. to 2:30. At 2:30, he was accorded an adjournment to come back at 5 p.m. My lord, what happened at 5 p.m. is summarized at paragraphs 25 to 28 of our submissions, and it goes like this, my lord. At 5 p.m., my lords, the Deputy President, the Counsel for the Deputy President, Senior Counsel Paul Mwite, submitted or told Senate that he could not trace his client, but that he had been admitted at Care Nostrum. He neither presented a medical report nor a report from any doctor. And that is an important observation. But beyond failing to present any document to demonstrate the truthfulness of the health status of the Deputy President, my lord, Counsel and his team, Senior Counsel Paul Mwite, Eminent Counsel Elisha Ongoya, and the entire team proceeded to walk out. And why did they proceed to walk out, my lord? Perhaps they did not read the wording of the Constitution and or the standing orders. Because a party, my lords, may be presented or may be present at trial by himself or through an advocate or representative. In this case, my lord, every opportunity was presented to the respondents to present, but they opted, my lord, not to proceed and not to provide any document to Senate at that point to, my lord, confirm, my lord, at the point that their client or the Deputy President, in that matter, was unwell and admitted. Senate then proceeded, my lords, to vote on that question. My lord, this is where Standing Order 85 comes in, and Rule 6 and 7. I will elaborate. Number one, my lord, under Standing Order 85, senators on a procedural motion may vote by acclamation. That vote was carried and Senate then voted to proceed. My lord, the catch here is Rule 12 of the rules that govern the proceedings. Once the 16th and the 17th of October 2024 were gazetted as the days that we had to proceed, that Senate proceeded, my lord, the proceedings had to be sequential and could not be stopped because of the requirement that the proceedings were time-bound and were to conclude in 10 days. The last day, my lord, that the proceedings were to conclude was the Saturday, the next day. My lord, unfortunately, Senior Counsel Mwite, and the Hansard will demonstrate this, my lord, had applied for an adjournment to the following Tuesday. My lord, we have demonstrated that the petitioner dragged the carpet from his own feet, deliberately decided to sabotage his own appearance when he had been in court in Senate for the last 2 days up to 1:15 p.m. before deciding not to be reachable by his entire team and the team making it worse by disappearing. My lords and your lordships, the petitioner had taken part in the cross-examination of all the parties. No case, my lord, has been presented before you that one, there was a violation of the standing orders of Senate. That's number one. Number two, that Senate did not consider some material defense to any of the charges that were proffered against the Deputy President. My lord, I just want to, for clarity of thought, submit that even on the submission that my learned friend Mr. Masharia made before this court, that there was additional evidence that was entertained by the Speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission, my lord. My lord, that was a substantiation of a charge on economic crimes that failed. Only, my lords, 5 out of the 11 charges proffered against the Deputy President petitioner hearing succeeded. Only 5 out of the 11 charges. how else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my lord. That out of the 6 charges, my lord, the deputy president was convicted on the gross violation of Articles 10(2)(a)(b), 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national cohesion and on the question that is laid before this court, my lord, that is on violating his code that requires him to undertake certain function and undermining the function of the National Security Intelligence Service. Ms. Kimotho of Kimotho and Company Advocates would want the Deputy President to apologize on that count. That's a live matter. But my lord, in the grant of conservatory orders, I submit, and this because I argued Munya, I argued Wajir, I argued Munya, I argued Mate. So I'm an authority in this area. Clearly. My lord, on the principles that the court considered, the Supreme Court considered in the Munya case, public interest, I think on the scales, weighed highest, that this court must take into account the import of a conservatory order issued ex parte against public interest. My lord, this is a country that is built on the Constitution of Kenya 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 as a rider that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the deputy president. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the deputy president, my lords and my lady, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a deputy president sworn in because of the dictates of Article 131 of the Constitution. My lady and my lords, a conservatory order is therefore inconceivable in the terms defined in the Munya case. A conservatory order of the nature issued by Justice Mwongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect Munya. This court would only use that authority to support the appointment of His Excellency Honorable Professor Kithure Kindiki, so that this country moves to the second level. I would urge you to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic of Kenya. But Lord, wherein would his remedies lie? Malayan friend body will submit. If it is a salary of 1 month, that would be compensable by damages. If it is a week salary that is 6 that I should have been or to have been Deputy President, that would be compensated in monetary terms. But this country, my lord, cannot be at a standstill and be held through litigation, because we need to have that position filled. My lord, if I move to the other point, my lord, we have submitted that since every opportunity was accorded to the Deputy President to present his case, and that he failed to present his case, my Lord, every argument before this court by my learned friends on the import of the processes of an impeachment fall on their back. They fall on their back, my Lord, because the authority in my movie Sonko and Nairobi City County Assembly, and I argued this one, my Lord. In part, I was in this matter. In this case, my Lord, the impeachment was upheld. In this case, Michael Mbuvi Sonko had sought to fault the process leading to the impeachment because there were no reasons given for the impeachment. The Court of Appeal rightly stating that one, there was the Hansard that contained reasons. Two, my Lord, in terms of an impeachment, my Lord, Mike Mbuvi Sonko was challenging the approach where the Senate sat as a whole, as a committee of the whole. The court finding, my Lord, that is an option that is open to Senate and cannot speak to the lawfulness or otherwise. Council on the other side submitted that there was need for a committee. Senate, in its proceedings, my Lord, in its wisdom, had voted to proceed through the whole House and accorded the petitioner all his rights that were due to him at the initial stage, only for the petitioner not to avail himself to take advantage of the second opportunity to be had. My Lord, we submit, my Lord, that unless the processes of Senate are faulted by my learned friends, the impeachment became final when the vote was taken before midnight on the 17th. And His Excellency, the Deputy President, Rigathi Gachagua, stood impeached henceforth. Unfortunately, my lords, this is an impeachment which has no comeback. It is like a death. You have died. You can't come back to life. But you can have certain claims in succession. And that is why we have the law of succession. Rights and remedies then come into question. My Lord, set aside the conservatory orders. Let us move on, my lords. The bigger public interest tilts in favor of the appointment of His Excellency Professor Kithure Kindiki, a very good man. Thank you, my lord.
Thank you.
My lord and my lady, my name is Modhomi Nkolu for the second interested party, and to that end we have filed a notice of preliminary objection dated the 24th of October, the year 2024. We have in addition to that filed a list and battle of authorities on that preliminary objection, and that list and battle is dated the 25th day of October 2024, and pursuant to your directions, those are the battles, my lord. I would suggest you hold them close to you because I'll be referring to them shortly. We have in addition filed written submissions, skeletonal submissions dated the 27th day of October 2024. Before I delve into the PO, my lord, a suggestion was made to you. I had forgotten to tell you, my lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my Lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my Lord, is that unless I am mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me why we have raised this PO and you find that I deserve to be laughed at, it's okay. My Lord, our PO makes only 3 interrelated points. The point number 1, which you will find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about enforcement of the Constitution to confirm whether anything. I'm here to tell you very shortly, my lords, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the president and the deputy president. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional, but our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the president or the deputy president of the republic. And that is the point made in paragraphs 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the president and the deputy president. But if we are wrong in that submission, my Lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. My Lord, why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lords, are set in paragraph 6 of our submissions. And the simple point is this: that our Constitution denies this court, the High Court jurisdiction, on countless matters that would fall under Chapter 4 on the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. It is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone were to come here and say that he was denied his Article 38, which is a human right under that election. My Lord, it is clear by dint of Article 58, sub-Article 5, that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My learned friend, Mr. Ngoya, talks of the word decency. We are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear if you have a dispute as to that matter. Never mind it has abrogated the entire Bill of Rights. The court you go to is not the High Court. It is the Supreme Court. My Lord, property is a matter of the Bill of Rights. Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my Lord, I'm here very humbly to tell you, the mere fact that someone has run to use screaming, Article 23, Article 165, does not without more mean that this court has jurisdiction to hear that matter. In other words, my Lord, for you to exercise jurisdiction over this matter, you've been told many matters, and as far as we are concerned, the matter before you, the substratum, is the impeachment. These things you're being told about Professor Kindiki are diversionaries or subsidiaries, because without the impeachment, we will not be talking about